My Lords, good morning. I appear with Professor Bailey for the CMA. I should say that the lead advocate at the hearing will be Mr. Turner, but he was unfortunately in difficulty today. Mr. Brealey next to me appears for advance. Mr. O'Donoghue with Miss Mockford appear for Sinven. Next along the row, Miss Ford and Miss Thomas for Auden. And at the end, Mr. Johnston for Allergan, who's also pointed out that the lead advocate at the hearing will be Mr. Jowell, who also couldn't be here today. My Lords, there are, I think, 4 issues on the agenda for this morning. They are, 1, advancers market definition.
Sorry, you've just got to let me, unfortunately, my computer seems to have taken against me today. I can't get into my computer. I'm going to have to rise for a minute or two to get into it. Give me. Hold on. Sorry, Mr. Jones. It's still not very happy with me, this computer, so just give me a couple of seconds.
Success.
Excellent. Now I'm listening to what you have to say. Maybe you could start at the beginning.
Well, I might skip the introductions, my lord, but I'll go to the four issues. There's one advances market definition argument in relation to which I am going to invite you to refuse permission today.
Yes.
2, the proposed list of issues for the hearing.
Yes.
3, the timetable for the hearing, and 4 bundles for the hearing. Of those 4, the first and
I
second...
think bundles might be better third, but yes.
Very well. And of those 4, the first and second are the ones which really will take time this morning, significant time this morning.
I'm not going to stop you, Mr. Jones, but our provisional view is that we don't think it's appropriate to bounce out anything at a pre-trial hearing, including that application, because appeals from the CAT are appeals on a point of law.
Yes.
And they're going to have to persuade us that they have a point of law. And whilst we may listen politely to the facts until our patience wears thin, we will need to be persuaded there is a point of law before they get permission to appeal.
Yes.
But the point that Mr. Brealey makes against you, which is that Market Dev, he wasn't party to Hydrocortisone 1, and therefore it's really a bit unfair if he can't at least put his point.
Yes.
Is a point that seems, anyway, to, as a matter of fairness, to point against bouncing it out at this stage. So, I'm not stopping you, but you can have a go, but that's what the hurdle you have to meet.
Well, my lord, I'm very grateful for that indication. Could I start with market definition? Because it is a point we need to reach a landing on today, and the list of issues is a point which can expand or contract depending, as it were, on the time available. And the market
it could, but we're very keen to have a regime which leads to an efficient hearing.
Yes.
So the orders of submissions and the duplication of submissions is quite important to the court.
My lord, I will deal in that case with market definition as swiftly as I can. I am going to try to persuade you to refuse permission today. Can I give you 2 headline points? The first is market definition is not only not decided in H2, I apologise, but it's not even the premise of anything which is decided in H2. So, my lord, I entirely see the force of the fairness point which you have put to me, if it were a valid point, but for reasons I'm going to have to spend a bit of time unpacking, there ultimately is nothing to the point, because market definition is simply not a building block of H2, and the tribunal makes that absolutely clear. The reason I need to spend a bit of time unpacking it is to see that I do need to take you back to H1 to show you what the market definition argument was.
If you're right, don't we just refuse permission to appeal at the substantive hearing?
No, because that's my second point. There's 2 aspects to that, my lord. The first is it would be a substantial issue for us to have to address, and so for us responsibly to deal with it at the substantive hearing, which is a rolled up hearing, we would need to spend considerable time.
Why?
Because we wouldn't be responsible
You
if we were
filed
simply
your
to
skeleton
proceed.
already
No, this is a point which we need to address in our skeleton,
in your reply.
in our reply skeleton. That's right.
But
And the
you
other,
know, I mean, if I may say so, it really is ridiculous to expect us to be at a state of readiness and knowledge today at a pre-trial hearing when we got the bundles yesterday, and some of us have rather tight diaries, to feel completely on top of it so that we're going to bounce out Mr. Brealey in an expedited appeal, permission to appeal, rolled up hearing, so that you have to spend a little less time putting in a skeleton. You know, you may well be completely right, Mr. Jones. I entirely get that. But it's not the way this court operates, picking things off at first instance.
My lord, I do understand there is a second aspect to it.
There's a what?
A second aspect to why it can't go ahead. And that's the point which Miss Ford has addressed in her skeleton argument. But it's absolutely right, and it's an important point, which is that market definition has implications, and actually only has implications, for the arguments which are being run or proposed to be run in the appeals against Hydro 1 and in the penalty appeals. And Intas, who are not here today because they asked the court not to participate in this, and that was discussed at the last hearing, made clear that an express premise of that was that market definition would not be addressed in this hearing. And I have the correspondence hand up in due course on that.
But you can hand up as much correspondence as you like, but I'm not going to decide today something about which we know nothing until you've just mentioned it, which is another party not appearing because of something else. We are deciding the issues between these parties to this appeal. If somebody else wishes to apply at some point to intervene because of some decision we take today, that will be up to them. We're sitting in open court. They will hear what they hear. But I'm really reluctant to use this directions hearing, which is to deal with submissions, timetabling, and everything else, to decide any substantive points, Mr. Jones.
My lord, could I just show you the paragraphs in Hydrocortisone 2 which really make the point
I've read it.
Abundantly clear?
But of course you can.
So Hydrocortisone 2, it's in tab 8.
Fortunately, I have it separately. Which paragraph is it?
It's paragraph 115.
We have
page
actually
three two
looked
now.
quite closely at that paragraph in preparing for this hearing. And to reiterate, we understand the point. There may be nothing in it from the respondent's perspective, but it is a broader point for us. Are we in a position today to block something out when all we're suggesting is it goes forward to a hearing where they've got to persuade us there's permission to appeal? Now, we're not expressing any view about the merits of this point from the respondent's perspective. We have read 115, we actually read it quite closely and discussed it. We're very familiar with the issue, how it arises, the extent to which market definition is really there, half there, what it means for analysing competition.
Well, my lord, could I, if you've seen 115, and it's only subparagraph 3, the structure of 115 is a bit odd in the sense that it starts by talking about a reason for Waymade to sign up. Waymade is the precursor to AMCO, and then has sub-bullets, but actually sub-bullet 3 is about a different point. It's about why Auden would have agreed to the 10 milligram agreement. And you've seen that the paragraph which Mr. Brealey hangs his hat on here is subparagraph 1, which is referring back to the market definition decision, footnote 150, referring back to Hydro 1, and then goes on to say, as we've described, market definition is an objective process used to identify and describe market power. It does not assist in informing the decisions of participants in the real world, where the prices are not as we've assumed them to be, and where the consumer we've hypothesised neither exists nor has the agency which we're attributing to them. That is all a reference to the novel way in which they approach market definition with a hypothesised consumer. So market definition...
This is so what? This is an object offence, doesn't require a market definition. Insofar as 115 addresses anything, it's basically saying look at the combination of facts, and I suppose if one, depends how one interprets 115, you know, as part of context, market definition might or might not be relevant. I mean, they're not always the easiest paragraphs to construe.
My lord,
why can't we take that view at the full hearing?
Well, of course you can, but we will need to be addressing the case on the premise that he might get permission. So we will have to go into, on this approach, Hydro 1, which I could take you to now, but I don't want to spend time on it, my lord, if that wouldn't be useful. 45 pages. Yeah. It's 45 pages. And this hypothetical consumer, which is what's being referred to in subparagraph 2, is the end point of a very long discussion about market definition, where you'll appreciate the fundamental problem is market definition requires you normally to say, how would consumers respond to a change in price, the SNP test, it's called. Now, the difficulty in this context is there are not price-sensitive consumers as there ordinarily are. There are patients who don't pay. There are doctors who have some price sensitivity, but they have the patient's interests first and foremost. And there are pharmacists who have different pressures bearing upon them. So they adopt this, it is a novel approach, it's right to say no one was urging it on them, to market definition where they constructed a hypothetical consumer.
But your answer to this is going to be all well and good, this is just fact, it's not law.
Well, my lord, that actually is not going to be our main answer to it. Our main answer to it is, it's not a building block of Hydro 2, because the very paragraph which Mr. Brealey is relying on is actually saying, in terms, we are not relying on our market definition.
But then it's a question of construction of a paragraph.
But my lord, there isn't, I've not yet seen what the alternative construction is, because you can see what they're saying. They're referring back to market definition. They're saying it's an objective process. Then they go on to say, in this case, the full label product was selling at prices far above the £10 we have hypothesised. However, the purchasers, pharmacies, wouldn't bear the economic costs. And so they're looking at the real world, and they say that in terms, in the real world, therefore.
Mr. Jones, we get all that, as my lord has explained. The problem is your approach is driving a coach and horses through the regime we established for this appeal. Reluctantly, we agreed to roll up 2 and 3 in order to have a hearing that was coherent, rather than one that they could say was incoherent in determining the appeal in 3. We will be sitting for 4 days to hear your appeal, substantive appeal for which you have permission, and therefore you have a reasonably arguable case on your 3 grounds of appeal, and that will be the burden of what we are doing. They, at the same time, when it comes to their reply, will be able to say the whole thing in 2 was deeply suspect on legal grounds that I'm not going to try and summarise now, and you will get a reply to that. If at that point you're absolutely convinced that you have not had a proper opportunity to deal with the market definition point, which the court is obviously taken with, you will say so, and you will say, if you want to allow them permission to appeal and allow the appeal on market definition, I've been handicapped and I want to have another hearing and 4 more days in the Court of Appeal to deal with it because blah blah. Alternatively, you will have the courage of your convictions and say this is nonsense because of the proper construction of 2, which happens also in competition law to be correct construction, and therefore this point is meaningless and it should be thrown out and permission should be refused. But sometimes advocates and counsel and lawyers have to have the courage of their convictions rather than saying I'm going to spend 3 days writing pages and pages and pages which will never be relevant. Now, you also have to have the courage of your convictions that if we come in with a completely different view that we've expressed today, that you will persuade us that it would be unjust to you to simply railroad through what is an inadequate argument of the point on this permission to appeal application, which is what it would be, albeit a rolled up one. So I really feel that I don't want the regime I've established derailed by this point. I want it to proceed as I have directed, and I want you to approach this appeal on the, if I may say so, proper broad brush basis with which it was begun. And if events go contrary to what you hope, they hope, sorry, contrary to what, I can't remember which side hopes what, doesn't matter. If it goes contrary to expectations or it goes in some different way, then you'll be fully entitled to say things have changed.
We would, for an option, be open to, if it went along those lines, you'd say, all right, grant PTA, but we have a substantive appeal later on.
Substantive appeal
We
later.
defer that particular point to a point in time when we can prepare properly. If you've got a procedural point, a fairness point, we won't be deaf to it.
My Lord, yes. That sounds like a way through, and I'm only pausing because I don't want to be arguing unnecessarily. So, my Lord, if the position is that we can address permission to appeal, but leave over...
On this point?
On this point, only on this point, but leave over the broader substantive... And I should just reiterate the wider procedural issues, because Mr. Ford has a... I've mentioned INTAS only because they're not here, but there are a range of other parties who would want to say...
I'm not saying you can, because it may be that, and I don't want to hear from 5 formal counsel telling me that this is all wrong and it's an absolute stone-bonking ground of appeal and you're completely wrong about everything. But if that appears to be what is being argued against you, and you have not had a proper opportunity, you will have liberty to apply to say, I must have a proper opportunity now that it looks like permission is going to be granted to put in, and therefore the argument you will adopt is don't do more than give permission, which one would normally do ex parte anyway, and you must have a fair opportunity to deal with the points and bring other parties in and goodness knows what else. And I'm not saying you will get that, because I don't want to tie the court's hands in any respect. But that would seem to me, and you'll have it on the transcript, as my saying, that would seem to be a very persuasive argument if we reach that position at the substantive hearing.
My Lord, I'm very grateful for that. This is a very important point for my clients. Could I just take a second
you can
to take
take
instruction? I'm very grateful. My Lord, that does sound like a workable way forward. Could I, though, just make one point, which is not by way of argumentation, but simply to make sure that this has also been expressed clearly by me, which is, at the last hearing, where these cases were managed very carefully, and there was a wide-ranging discussion about how they could proceed sensibly, given all the other moving parts, what was agreed was that these would be appeals against Hydro 2 and Hydro 3 on liability only. And the question of market definition was expressly parked by INTAS. And it wasn't,
what?
Was expressly, I said parked, but was expressly raised by INTAS as a point which they understood would not be live in these appeals.
Which hearing was that?
There was a permission to appeal hearing at which Mr.
Right.
Teacher appeared for...
We didn't know, well, we don't have any detailed knowledge of that.
Yes, that was...
When was that hearing? So you mean the hearing in this case?
It was the hearing in this case.
On this court?
On the last occasion, yes, exactly. Yeah.
Right. In front of us?
That's right, that's right, my Lord. That's right.
I don't remember.
That's right.
About that.
Well, and I'm not meaning to be argumentative, but I just simply feel because of INTAS's involvement and the CMA's involvement with INTAS in agreeing that they wouldn't take part, I just wanted to make sure, I appreciate these are fairness points to be raised later down the road, but I just wanted to make sure that I had made clear that there was an express discussion there in the papers and in advance of the hearing about the fact that market definition was not on the agenda. That was why INTAS...
But not in the oral hearing.
I apologise.
Not in the oral hearing.
Well, it wasn't raised in the oral hearing.
No,
Mr. Brealey's... Mr.
it's
Brealey...
just-
Well, no, but my
I'm
Lord...
wondering if my memory is...
No, it wasn't raised in the oral hearing. No, quite right, quite right.
I was there, you see.
Mr. Brealey's written submissions, all of my learned friends' written submissions in advance of that hearing, identified the points they wanted to take, and that formed the basis for the discussion. And Mr. Brealey's submissions identified what he calls the bifurcated market point, which is the point we're happy to proceed with, but didn't say market definition was challenged. INTAS made clear they were not participating because market definition wasn't being challenged. And so, my Lord, I'm only making... I appreciate...
You're making that point, put it on the record.
I'm putting it on the record.
If the worst happens, you can say to me, I told you I had to have an opportunity to bring this back, and therefore you mustn't do this or that.
And also so that when
And
Intas
others are also affected
at
whose interests need to be safeguarded.
because it was the CMA with Intas applying for them to
You
be
know, we
let
don't,
out.
Mr. Jones, we don't set out to be unfair here. We actually set out to hear both sides of the argument and decide the case fairly according to the evidence and the law. In this case, the law. So don't worry unduly. You know, what we want to do is, in a very complex situation, get through, for the benefit of all, the detailed argument in a way that gives us the best possible opportunity of doing what I just said. And we're not trying to shut people up or bulldoze people or railroad anybody or prevent people raising proper arguments, least of all you.
But, my lord, I fully appreciate it. I'm grateful for that. We had also said to Advance in particular that we were not going to put in a respondent's notice on market definition.
Right.
We've not, because we didn't think it was live, we've not done that because it's a Hydro 1 point in our view. And so, my lord, that's another point which, if and when we come to these fairness points, we will need to raise.
Well, you don't need to put a respondent's notice in to a permission to. I see. You would.
We would if it was substantive.
Yes. Okay, made that point. All right. Well, we're going to proceed like that. Yes, Miss Ford. I was hoping that I might keep you all in your places, but I've obviously failed.
May I impose upon the court for maybe 2 minutes on the same issue? We are not asking the court to make a substantive decision today. We are not asking the court to refuse permission, although we reserve the right to say so in future. What we suggest is that this point should be dealt with in the same way as the excessive pricing appeals and the penalty appeals, in that it's essentially more properly a point for another day.
You want it hived off.
We say it's more appropriately hived off. We have heard what your lordship has said about the scheme that the court set out last time, and in our submission that is a solution which is entirely consistent with the way in which the court approached the case management last time. The court's obviously directed that closely interrelated issues should be heard together at this forthcoming hearing. In our submission, market definition is clearly not the sort of closely interrelated issue that ties in with issues of the cartel.
And have you suggested that to Mr. James, that you just agree to hive it off?
Well, we put it in our skeleton argument.
Well, he sort of said he agreed with you, but I'm not quite sure. Should we ask him?
Well, my lord, I half agree in this sense.
You half agree.
If the point remains live, as my lord indicated, then it has these cross-cutting implications for the other cases. However, the way my lord has suggested dealing with it, I think, resolves that in the sense that we can deal with it at the permission level at this hearing. We can deal at this hearing with the other object points which Mr. Brealey raises, which really are agreement points. They're not going to take much time. They're very short points about object infringement. They go along with the agreements infringements. They have nothing to do with the other appeals. Hiving off the whole of ground 2, which this would necessarily entail, this forward suggestion would necessarily entail, because market definition is part of ground 2. So hiving off the whole of ground 2 on object to hear it with possible appeals on other issues would introduce complexity to those appeals, because you would end up having appeals which are dealing with abuse of dominance and with this agreement issue, which really has nothing to do with the abuse of dominance.
We've also got the problem that paragraph 115 is in Hydrocortisone 2.
Yes.
So in some respect, subject to how we construe that paragraph, the cat has brought its conclusion inferentially from 1 into 2. So it is there in 2, and at some point we have to grapple with it in 2.
Yes.
We're conscious of the fact there's a risk of trying to decide something which may become relevant to 1. Yes. But I mean, this is not a perfect world, this case, by any stretch of the imagination. We have to find a workable way through, even though there may be some rough edges to it.
Yes.
There's no easy solution to any of this.
There's absolutely no easy solution, but hope it's clear that from our perspective, what we think is the best solution is we can deal with object as part of these appeals, and we can deal with the market definition aspect of that as a principle, as a permission level point, and it will then be dealt with, I think, briefly and easily as part of these appeals whereas sending it off to require the court in the other appeals to think about the infringement and the object issue would not be easy, because they'd have to understand the agreement, they'd have to understand all the issues surrounding it.
I think you were just standing up to say whether you agreed, and the answer was you didn't. As Ford.
To be clear, we are not suggesting that the entirety of the object appeal goes off to another day. Mr. Jones, in his submissions, has just made a distinction between the entirety of the object appeal and the particular market definition points, and he's suggesting the particular market definition point can be dealt with only at permission level. Our suggestion is the particular market definition point is the point that needs to be hived off to be dealt with alongside hydrocortisone 1. We say that it is a qualitatively different sort of point.
So why can't you argue that at the permission, at the full hearing, as well as he can argue that what he wants to argue about it only being a permission application, and that if it were to be granted, it should go off to a substantive hearing. So you'll be saying send the whole thing away. He'll be saying that little bit should be sent away only if you're granting permission. Because I'm going to say the same to you as I say to Mr. Jones, which is it is not the purpose of this hearing to decide anything substantive. And by hiving it off, we would be deciding, for the reasons my Lord has given, something substantive, and I don't want to. So I'm as reluctant to deal with it in the way you say as in the way he wanted it dealt with originally. I would prefer to leave all these points open for the time when we'll be in a state of perfect knowledge about this case, which will be in July, not now. Is that all right?
I hear what your lordship says, and if that's the way the court wishes to address it, we will address it in that way. We do have a concern about the time available in the July hearing, and in our submission, hiving off this particular point is not making a substantive decision in the way that it would be if we were asking the court to determine permission one way or the other. It simply means that in the same way as the related penalty appeals and in the same way as the related excessive pricing appeals, they will be dealt with at the appropriate time.
Well, you can say that at the appropriate time. Today is not the appropriate time. So that's the way, subject to anybody wanting to say anything else, we're going to deal with this. Is that all right? Right. We may not be all right, but it's the way we're going to deal with it. Okay, so we move on with that marvellous introduction to the points that you tell us are only going to take a few moments to resolve. I'm not completely confident of that, but let's hope you're right about that, which is duplication of submissions and argument. And for this you have put forward, thank you, in your skeleton, some suggested lists of issues. And have you discussed them with the other counsel?
Yes, my lord, if I can turn that up, I will explain where we have got to. It's on page 6 of the bundle, tab 1, which is also page 6 of the skeleton if you have that separately. We set out 8 issues. These were set out 2 weeks ago in correspondence, save for the fact that since then we added in the CMA's grounds. The respondents have been able to agree 3 of them. Those are issue 4, issue 7, and issue 8. Yes, and one of the friend points out, and some of 3, which I'll come back to. Beyond that, they've not been able to agree the list. Indeed, they haven't reached a common position between themselves as to what the other issues should be. And what they have proposed instead is that there should be a process after today in which we all seek to agree the list of issues. And one of the concern which we have with that is that today was supposed to be the occasion to grasp the nettle, to ensure that these issues can be dealt with in an orderly way. It is a very difficult task. It's a difficult task because there are so many overlapping issues which have been dealt with in so many different ways by my learned friends. And we have set out, as I say for a while now, what we think is a fair and logical approach, and this took a lot of thinking about to produce this list of issues. We would like to use, if possible, a list of issues to structure our own reply skeleton next week, because that would seem a sensible way to proceed. And we are concerned that kicking it down the road might exacerbate the difficulties.
Can we just end to a little detail? What they don't agree, as opposed to what they do agree, seems to me at first sight to be your appeal, which may be semantic formulation of how you put your appeal, which may not really matter, because the first three issues are your appeal, and we've got your grounds of appeal, and we've got your skeleton, and we know how you put your case, and they can say what they want to about it. So, in a sense, I'm not sure that formulation of those issues matters. 4 is helpful. Then we come to their appeal, where it's 5 and 6 that are not agreed, as I understand it, and those may be a little bit generic and broad brush, and they would want to say there's a lot of detail in our case which they don't encompass. Again, none of that really terrifies me. What I want by way of a list of issues is not like a list of issues for trial, where every sub-factual question is identified and ironed out, which I always hated even for trial, by the way, but it's a long time ago that I sat at first instance, but when I did, I wanted issues that were 8 or 10 like this. So I think that these are more headings than lists of issues. I don't think there's any merit, speaking for myself, my lord will say if he disagrees, I don't think there's any merit in agreeing a formulation of words semantically with which you all agree, because you won't. And so I would urge the other parties to say these are headings under which we will address our points, and what I'm concerned to ensure is that under these headings, points are not addressed in 4 different ways by 4 different parties, particularly connected parties in some cases. And what we have seen, and I know you won't give them much time, and I know therefore it's always difficult for legal teams to work together in the way that we judges think you all should. But there are different facets presented, different approaches presented in issues 5 and 6, really, which are not particularly helpful to the argument, and we would like to see a lead counsel, a lead approach, if that is at all possible. I don't think it can be done today, but I think it's just a case of me sort of banging the table today and saying I'm going to get very cross if I hear from Counsel 1, who's the lead, a designated lead on point 1, an approach which is like this, and then I hear from Counsel 2 something completely different, which takes as its premise a different approach. Now, anyway, we haven't got time to have different approaches, and if it's a legal point, you know, it's very hard to see how one can completely come at either there is a legal point for which they should have permission to appeal, or it's just quibbling about the facts. So, you know, if you start quibbling about the facts, I mean, it's the way my lord put it to me earlier today. He said, we will listen patiently, but only so far. You know, because...
Reasonably patiently, I think that's it.
Well, I'm known for my patience, my lord. But you get the point. So, I mean, we're quite...
Yes.
Maybe we should hear, with that introduction, I mean, we're attracted by your list by way of headings.
Yes.
We can see you've done a lot of work on it. But if it's more than headings, then it may be controversial and may not really, time is not well spent on that,
no.
Particularly with the expedition we've imposed on this case.
My lord, with that, there is a disagreement which has crystallised, but my lord, it doesn't strike me that it would be sensible to spend the court's time on that now. We can, I think, take that away, what you have said.
No, well it's really for the respondent teams to try and to what I would. I mean, I'm not asking them not to raise important points that are individual points. Of course, I'm not. And you'll always have the tail end to say, I'm sweeping this up, but I really want you to understand our case, which is not Mr. Brealey's case or Miss Ford's case, blah. So let's hear from them and then we'll resolve. Who's going to go first, Mr. O'Donoghue?
My Lord, if I can deal sequentially with the narrow list of issues point on the one hand and the oral hearing on the other. On the list of issues, we entirely agree the list of issues would be extremely useful. Cutting to the quick, your Lordship's indication that this should be operate at a high level of abstraction and aggregation is, if I may say so, extremely helpful. As your Lordship adverted to, the more one descends into detail, the more controversial and dug in these things become. So if this can operate at a high level of abstraction, it will be very much, I think, capable of agreement. Now, from our perspective, 50% of the issues have been agreed. We got this list of 8 issues yesterday morning. We agreed half of them by the afternoon. This is complicated. We are not a monolith. We will need a small bit of time to iron out differences between us. My learned friend makes a perfectly fair point, which is ideally before his skeleton on the 26th, we need to reach a landing point on the list of issues. And we're content to do that. So what we would suggest is that by Monday, we would send to the CMA a final version of a proposed list of issues.
Monday's what date?
The 24th.
I'm giving them 2 days. You'll send them a final
List of issues based on their list of 8. And as I said,
That assumes they'll agree.
well, at
Can't
least.
council just get in a room and beat each other up and come up with a list?
Well,
What we used to do in the good old days.
that may also be an option. But I'm starting on an optimistic note, which is with a high level of aggregation, this ought to be capable, frankly,
This will all be done without
of
violence
agreement.
or bullying.
Well, not too much, my lord, anyway. A proportionate amount. So we say that there's a process in place whereby by Monday, either something is completely agreed, or at least it's clear where we disagree. We say that meets my learned friend's point.
What do you say about treating these as headings rather than trying to agree a formulation?
Lord, that is clearly the way forward, because
Yes.
the more one unpacks the heading,
Yeah.
the more one gets into controversy. And of
Yes.
course, as your Lordship remember from practice, people get very worked up about points that frankly seem quite semantic. And the solution is the higher the level of aggregation, the easier it is. And frankly, the highest level of abstraction is a pure heading. We think done in that way, there shouldn't be
So
scope
will
for
you
reasonable
be-
people to disagree.
Will you be going back to them, and I'm exaggerating for the sake of emphasis, with 20 headings, or are you content to
No.
have 8 or 9 headings and maybe 10? I'm not trying to constrain you.
My Lord, at the risk of crossfire, it will be more like 8 or 9
8 or 9
than
headings.
a bigger cardinal.
It's important from your perspective, because if we want you to avoid duplication, your headings need to be the guide which enables you to divide the work between you.
Indeed.
Exactly.
And as your Lordships have said more than once, this is complicated. There are a lot of moving parts, and it's in everyone's interests that we know on the 10th how we're fixed and who in principle is dealing with.
It's in everybody's
issues.
interest.
Indeed.
We can get down to the kernel of this case as quickly and efficiently as possible.
My Lord,
And
absolutely.
we are not diverted by pettifogging issues of fact or different ways of putting the same point.
My Lord,
Because
yes. And
even the kernel of the issues are themselves complex and
Yes.
important. And we're
Indeed.
conscious of that.
And by the end of the hearing, your Lordships may have a different set of issues.
We may well.
We
but,
may well.
You know, we have an entirely open mind
Yes.
and we haven't read all the papers yet.
Yes. So, well, we would suggest that as the way forward. I am optimistic there will be complete or very substantial agreement by Monday.
Right. And so what you're suggesting is, that, and you can't do it more quickly than Monday because Friday would be so much better.
What I'm hearing, warm encouragement right and left, so the answer is
So
yes.
if you could do it by Friday, middle of the day, then that gives the CMA an opportunity to have a think about it and come back to you immediately after the weekend. And then this council of war that my lord suggests could take place, if needed, on Monday.
If needed, yes. Well, that seems a very
It's a
sensible
perfect
way.
opportunity to ruin Mr. Jones's weekend.
Well, I was trying the opposite.
And many others, But I mean, that seems to me. I mean, what we are not looking for the case to be decided by reference to the formulation of issues.
God forbid.
No, well, I mean, because you're asking me to recall days in practice, and I always used to think the formulation of issues and the chronology decided the case, and that was a jolly good thing to therefore impose upon, particularly if the other side were in a lesser state of preparedness than our side.
Oh yes, that old trick.
That old trick. So, what I'm not concerned about the formulation. I'm concerned about the hearing being most effective, and therefore you, and this is the reason why I do want you to have a proper opportunity to go back to them to say this is the way we divvy it up, and that's why we put an extra heading in.
Yes.
Say.
Well, that seems very, very, very sensible, if I say so. They're experienced advocates on all sides, and I'm optimistic. It is not beyond the wit of man or woman.
I mean, I did consider requiring you to go back and resubmit your skeleton arguments without the overlap and duplication. But you'll be delighted to hear that we haven't finally decided yet, have we? No. But we decided that would be inappropriate because of the expedited timescale.
Well, Lord, the expedition has imposed an enormous.
But so this
on
is
everyone.
your opportunity to
This is the-
divide it up, to say to them, we want this heading split into two because we want Mr. X to deal with that and Miss X to deal with that.
Well, we will do that by midday on Friday.
Yeah.
I mean, Lord, in the hearing, as I hope you picked up from Sinford's skeleton, we entirely agree there has to be a lead person on a particular point. At best, there may be a sweeper role for somebody else, but that is where necessary, rather to be encouraged as of right. So we have that very well in mind, and the 4 respondent advocates, we have to some extent started to divvy things up. By the time we get to the hearing, there will be a complete indication of the exact divvying up. So we've given a very clear sense of that in our skeleton. So, for example, if we take the meat of the CMA's appeal ground 2, there's A, B, C, D, and E. What I envisage is that Mr. Brealey and I would deal with the subgrounds, and then there would be a sweeper role by some of my learned friends. So one can see the way forward here. It's not it's not that complicated.
Do you accept that there isn't really a need for us to make formal directions on this point if there is a clear understanding as a result of this hearing as to what's going to happen in the next few days?
Well, we would strongly encourage the court not to make those directions. The straitjacket can be counterproductive in this context. And again, you've experienced people before you who understand how this works.
Okay. Well, okay. Did you want to say something?
No.
Okay, Mr. Jones, I take it you're all in agreement with that. Mr. Jones,
Yes,
is that a solution?
that sounds like a solution, my lord, yes.
Okay, excellent. Good. Now, bundles.
Bundles.
And let me just say that a 41,000-page bundle, however electronically enabled, is not attractive to me.
My lord, that could be the end of my submissions because that is my point. My lord, the broader context is you'll have the decision, and the decision in these cases, in this case, but as in all CMA decisions, itself cites from documents as does the tribunal decision. And so the extent to which my learned friend actually needs to show you additional documents is questionable. If they do, we'd like to know what they are in the normal way. Keeping in mind, Mr. Turner, for example, wasn't in the tribunal hearing, so the idea that he might need to be, nimble though he is, nimble enough to turn to some new document in an enormous bundle is not something which we think is practical. But my lord, our proposal is that we simply stick with the order, which is an order that already provides for the parties to liaise on bundles. I think my clients have to suggest appeal bundles by tomorrow. They're preparing to do that. There's a timetable in place for my learned friends to respond with whatever documents they want in. It's just the normal process.
Right, but I mean, there's a limitation on size for the Court of Appeal.
Yes.
I can't remember what it is, but it's 400 pages.
Oh, it's short, and I expect that we're all expecting it may, once we've looked at these bundles, need to be longer than that.
Right. Well, that's fine. I'm not saying we're going to refuse that permission, but we are likely to refuse permission for 41,000 pages.
My lord, it looks like none of my learned friends want to challenge that. So, well, that's that point.
So you'll carry on and do what you need to do, and we come then to what I think is. Yes, well, I only work digitally, as probably everybody knows, so I'll need it digitally.
Yes.
About 2 of the members of the court do want hard copies as well.
Yes, I'm grateful.
I think the question of submissions is possibly important. Do you disagree about that?
We don't. We have discussed it,
Right.
and this is a point which we've managed to agree on.
Right.
Can I
what
explain
have
what
you
we've
agreed?
There's obviously some overlap between, as it were, the CMA's appeal points and my learned friends' appeal points. So those are not watertight categories, but they are broadly recognisable categories, if I can put it that way. And so the proposal is that each side has 2 days, so the respondents, of course, 2 days between them. The CMA will open its appeal and will spend 1 day doing that.
Yeah.
My learned friends will respond to the CMA and open their appeals, which will take them applications for permission, which will take them 1.5 days.
Yeah.
The CMA will then have its, as it were, its reply and its response to the permission applications, for which it asks for 1 day, and my learned friends then have their reply half a day. And we've all, well, learned friends have said they might need to be flexible on timing, in the sense that they might spend longer on their openings and less time on their reply, but they will keep to 2 days. And I've said the same to my learned friends. I assume they agree that we would also have that ability to be flexible if needed.
Can I just raise the question of the specific days? We start, as I understand it, on the 10th of July and go through to the Friday night.
Yes.
Which is 3 days, and then the 4th day is the 16th.
Yes.
In extremis, I have in my diary the afternoon of the 17th, because, as you may know, it's the state opening of Parliament in the morning of the 17th, which I have to go to. We all have to go, maybe not, my lord, but the Chancellor too has to go. But I'm not encouraging you to use that half day, but it is there.
My lord,
I would be disappointed to hear that council couldn't make it or something like that and was asking for another time. So that will be when any run over takes place, if necessary.
Yes, I'm grateful.
All right. Good. Well, marvellous. Less than an hour. Miss.
My lord, a very brief point arising out of where we've come to on market definition. We would seek permission to produce a short supplemental skeleton, because we have not had the opportunity to address in writing Mr. Brearley's market definition points in the light of what the court has said today. So we would ask.
Short, 5 pages?
I anticipate we can accommodate that, yes.
Very good. You have it.
Grateful.
Good. Well, we'll look forward to seeing you all on the Wednesday, the 10th of July. Bright-eyed and bushy-tailed at 10:30 in the morning. Thank you all very much.